Thank you, Mr. Chairman. Judge Craftsher, I'm going to read you a quote, and you tell me whether or not you know who said this, okay? 100% of the women at call centers have been abused. It's an atmosphere of abuse. Anytime we see a call center person, female, all have been abused. Do you know who said that, Judge?
I did. It was taken out of context.
Well,
sir, your microphone, can you repeat that, sir?
Yes.
He said it was taken out of context. Well, let's put that in context. Judge, did somebody testify to that at a lower level? Was that in the record?
No, sir. That was my experience.
Did you rely on a learned treatise? You made a point of saying in your opening statement how much respect you pay to the federal rules and the Constitution. Was that a learned treatise you relied upon, Judge?
No, that was my experience over 20
So you
years.
made yourself a witness even though the federal rules are very clear that judges are not witnesses. Is that what your testimony is, Judge?
That was my opinion, not anything. It was my
100% of female employees at call centers have been abused.
I didn't say that. 100% of the people that appeared before me have been abused.
And you relied on no learned treatise, no testimony at a lower level, just your innate sense of medicine?
No, that's been my experience having hearings.
Well, let me ask you about another one of your experiences, Judge. I want to read you another quote and ask you whether or not you recognize who said this, okay?
Mm-hmm.
How did your family discipline you? Did they hit you on the butt? I'm starting to do some analysis. It's starting to be when women are hit at an early age, they start developing problems in their 20s, late teens and 20s. My ex-wife told me about this. There's something in a girl that's a sexual thing. It arouses certain things. Did you say that, Judge?
Yes, I did.
Did you rely upon a learned treatise in reaching that determination?
No, I relied on.
Did you rely on something at a lower level, a hearing, a witness testified to that?
No, I relied on my experience hearing case over 20 years.
Judge, I hasten to add, because you made a point of saying in your opening statement that your first responsibility is to the Constitution and the federal rules of evidence. Are you aware that judges can't be witnesses? Are you familiar with that, Judge?
I don't consider myself a witness.
You just testified to your own personal experience. If that's not a witness, what is it?
That's a personal opinion.
Judges can't express personal opinions either. That's why we have something called experts.
So that's
Did an expert testify to that, Judge?
That's called a First Amendment right.
You're considered, so you have a First Amendment right to say whatever the hell you want in a hearing. Is that what you're saying?
No, sir.
And you can rely upon that when you're spending taxpayer money?
No, sir. But that's an isolated case.
Well, it can't be an isolated case. I just cited two.
Yeah.
And my colleague cited others.
Yeah. You're taking isolated cases. I've had.
Well, let's go a little broader than that, Judge. What is your reversal rate of the hearing officer? Is it in excess of 90%?
Yes, it's based upon testimony given to me.
All right, and it has to be adjudicated twice before it gets to you, right?
That's correct.
And only if it's denied does it get to you. So 90% of the time, the people under you are wrong.
No, I want to be able to cross.
Well, it has to be, or you wouldn't be reversing them. They've denied benefits, Judge, and you've reversed their denial. That means that you're hiring some really dumb people to be hearing officers because they're wrong 90% of the time.
No, sir. I want to be able to cross-examine the people from Social Security.
I'm glad you mentioned cross-examination.
Right.
I can't tell you how glad I am.
Yeah.
Because in every other court proceeding, there is someone cross-examining the witnesses, but it's not a judge. It's an attorney, and that's true in misdemeanor crimes, that's true in felony crimes, that's true in civil cases. So what I think you need, Judge, is I think you need an advocate and an attorney for the taxpayer in the hearing room. Because I don't want you cross-examining witnesses. If you really think that paddling a child leads to sexual issues, I don't want you doing the cross-examination. And if you really think that 100% of CNAs have been abused and 100% of females in call centers have been abused, I don't want you doing the cross-examination, Judge.
Sir, we wear three hats. One hat is the Social Security hat. The other hat is the claimant's hat. The other hat is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right.
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear 3 hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true.
Sir,
you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings, Mr. Cummings just exposed it. That's your document.
The attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer.
Good.
We're going broke. Mr. Chairman, I know I'm out of time, but I'm going to tell you a story from Spartanburg real quickly. I had a judge call me. He's apolitical. And he said, I just sentenced someone for calling under people's houses and stealing their copper. And he said, what really struck me as being unusual, Trey, is he is 100% disabled in the back. I want you to think about that, Judge, and I want you to think about one other thing, too. I went on a tour of something called a workability center, where people with special needs value work enough that they go to work every single day. And there was one man who was confined to a wheelchair, had no use of his hands or legs, but his job was to encourage his fellow employees. There is inherent value in work. And one reason your backlog may be so big is because it's so damn easy to get benefits.
Not for me. Not for me. I hear every case. I see every person that's ever appeared before me. Everyone.
You reverse the hearing officer over 90% of the time, Judge. 90% of the time, the person at the first level is wrong in your judgment, and you are citing your own version of medicine. 100% of the people are abused. That if you paddle a little girl, she's going to wind up with sexual issues, despite the fact it's not in the record, Judge. Well, you may be a judge, but you're not God.
Well, let me explain to you. If I had this person in front of me that was down below, I can examine him on behalf of Social Security, and that would allow the claimant's rep.
Well, then why don't your colleagues have hearings? Why do they do it on the paper? If it's that important to eyeball a witness and assess credibility and cross-examine them, why are you doing it on the paper?
That's what I said in my remarks here. We need the ability to be able to have the witnesses who give any comment down below should be appear before me, so I can examine them, and they can be cross-examined by the.
I want them being cross-examined by an advocate for the taxpayer, Your Honor, with all due respect, not a judge.
Well, then you need an adversary system, which we don't have today.
Mr. Horsford.
The other hat is the claimant's hat. The other hat is the Social Security hat.
Where's the expert witness hat? You just said you were an expert witness.
We have an adversary system, and I have the right.
It's not an adversary system. There's no advocate for the taxpayer that's in the courtroom.
We have a non-adversary system, sir. It's a non-adversary system, and I have to wear 3 hats.
It can't be too adversarial, or you would not reverse the hearing officer 90% of the time. And some of your colleagues, 99% of the time, they reverse a hearing officer. And we mistakenly, Judge, thought it was because you were eyeballing the witnesses so you could assess credibility. But we learned from your colleague, Mr. Taylor, that that's not even true. Sir, you don't even have a hearing. You just do it on the paper.
Sir, it's not eyeballing the witness. I take testimony. I have had here, this sheet has...
And who does the cross-examination?
It has 186 ailments on it.
Who does... Well, that's your document. Mr. Cummings, Mr. Cummings just exposed it. That's your document.
The attorney also provides one for me.
The attorney for whom?
For the claimant.
That's my point. There is no attorney for the taxpayer.
Sorry.
Would you seat a juror in a trial who referred to your client as an obscene body part?
I really have trouble giving you an answer, except that sounds
well,
like
then you would starve to death as a lawyer if you can't answer that question, Professor. You would seriously consider seating a juror in a trial, a criminal trial where your client was accused of a crime. If that juror had referred to your client as an obscene body part, you would struggle with whether or not to strike that juror?
Well, it doesn't sound too good.
No, it's not. And I'll give you some free litigation advice. You'll want to use one of your strikes on that juror. How about if you were a prosecutor and one of the potential jurors referred to the police as terrorists who are going to bring the country down Would you seat that juror in a criminal prosecution if you were the prosecutor?
I wish I saw the connection here, but that's...
I'll give you the connection. Lois Lerner just referred to conservatives as an obscene body part, and she said we were crazies and likened us to terrorists.
Well, Mr. Chairman, if
You are not recognized. The gentleman from Georgia is not recognized.
well, would the gentleman yield?
No, sir, I will not. Let's go to the regulation, Professor. Conflict of interest for the department. People like standards. They like bright lines. So I thought it'd be interesting to go find out what the Attorney General's standard is for recusal. And you know when he recuses himself? I'll quote him. When there's the potential appearance of a conflict, he recused himself from a criminal prosecution when there's the potential appearance of a conflict. Those are his words, not mine. So that's the standard for when there should be a conflict. I want us to analyze whether or not there could possibly be the potential appearance of a conflict. You have the President of the United States. When I ask a question, it'll be very clear, Professor. The President of the United States, in the most widely viewed television show in our country, said there's not a smidgen of corruption. You don't think that is the potential appearance of a conflict?
For the issue of a special counsel, which is what I'm here for, I think.
How about give me a yes or a no, and then you can explain your answer.
I think it's irrelevant what the president says to whether there's a conflict of interest.
What if a judge says, let's go give this guilty bastard a trial? Is that irrelevant? Would you want that judge? If he prejudged the outcome of a prosecution, said, let's go give this guilty guy a fair trial.
Given the independence of the public integrity section for the last 30 years, I don't think it matters what...
So you don't think it matters that the chief law enforcement officer for this country, before there is an investigation, while there are emails missing, before he's analyzed one scintilla of evidence, prejudges, and says there's not a scintilla of corruption? You don't think that matters? You don't even think it creates the potential appearance of a conflict?
I absolutely reject that the standard here is the standard you're naming for recusal. If he recuses himself, it's still the same justice.
How about when the
without a
Department
special
of Justice
counsel who does it?
trades
Only the
emails
Attorney
with
General.
Lois
Sorry.
Lerner seeking to implement an idea from a Democrat senator? Do you know Senator Whitehouse?
My understanding is the idea was rejected after the meeting in question, that the idea was...
I'm simply saying, do you really want the Department of Justice and the IRS taking their prosecutorial advice from a Democrat senator? I thought the Department of Justice was blindfolded.
I'm glad they rejected the idea.
I'm sad that they even discussed it. I'm sad that they even discussed pursuing, because when the AG sits where Professor Rotunda is, all we hear about is how he doesn't have the resources to actually do his job. And now they're going to contemplate manufacturing false statement cases?
I thank the gentleman. I thank Mr. Chairman. Ms. Nkapi, among many limitations in life is my inability to glean other people's motives or be able to read their minds. I could have sworn in response to a question you received from Mr. Cohen, you suggested race was the basis for why we may have this constitutional perspective. Did I understand you correctly?
I believe I was responding to the question about is there an explanation about why?
Well, let me offer another explanation to you, okay? Not a single Republican who is here right now ever served under a Republican president. Not one. So I hope I do live long enough to hold a Republican president to the exact same standard that I'm holding this one. But for you to run to race as the explanation for why we hold the position that we do, Harry Reid had a very different perspective on recess appointments when there was a Texan in the White House, and none of us accused him of geographic discrimination. In fact, hell, for that matter, Senator Obama had a different perspective on executive overreach than President Obama, and nobody runs to race as an explanation for that. So I would just caution you to be careful when you try to import motives to people. With that, what are the limits of prosecutorial discretion?
So among the limits of prosecutorial discretion is that the president must comply with existing statutes such as the appropriation. So the president can't simply stop deporting everybody. And in fact, what they've done here is they've listed new priorities.
So he can't stop deporting everybody, well, I mean, what are the limits? So as long as he deports one person, then that's a proper exercise of prosecutorial discretion?
No, under the current appropriations, the
I'm not talking about
Congress has
appropriations. I'm talking about the
100,000.
constitutional doctrine of prosecutorial discretion, which if you marry up with the pardon clause means you don't have to enforce it, and if they do break it, you can pardon them for it.
Right, so under the constitutional doctrine, we should take two pieces. One is you've got the take care clause, which says that the president must take care to enforce the laws.
Mr. Cappy, your answer is much more complex than my question. What are the limits of the doctrine of prosecutorial discretion?
The limits are that the president must enforce the laws based on statute. So one is...
I thought he just announced he wasn't going to do that he was carving out categories and exceptions.
In addition...
And not on a
other
case-by-case
priorities.
basis, too, for entire categories.
No, he is not stopping, he's not saying that he is not going to enforce the law whatsoever vis-a-vis those individuals. He is saying he is creating a program by which individuals can come forward if they meet certain criteria, and they will be held accountable to apply, pay a fee, pass a criminal background check.
But that's not the current law, right?
That is what is possible under deferred action, and that is what he has developed. Correct.
Well, I want to talk to you for a
Deferred
second
action is
about that background check, and I want to get into the policy a little bit. Can you tell me what serious criminal is? Because when I look at the White House talking points, they're interested in serious criminals. So tell me what a non-serious criminal is.
It could include somebody, for example, who has been detained for shoplifting. Let's say a 22-year-old who takes lipstick, and that's a misdemeanor, and she.
So just misdemeanors, a non-serious criminal refers to misdemeanor convictions?
Right, and in fact, there are certain misdemeanors that are considered serious criminals under the recent memos from the Department of Homeland Security as well.
How about domestic violence? How many domestic violence convictions can you have and still remain?
I believe domestic violence is considered a serious crime under the new...
It wasn't under the comprehensive Senate immigration bill, which I have heard lots and lots of my colleagues embrace. I think you could have up to 3 domestic violence convictions and still remain on a path to something under the Senate version. How about recidivist DUI?
I believe DUI completely disqualifies you as well.
A single DUI conviction
Correct.
is considered a serious criminal,
That's
even
my
though it's a
understanding.
misdemeanor.
That is my understanding, yes.
Well, where could I go to find out whether or not that understanding is correct or not? It wasn't on the White House talking points. They talked about gang members, but I'm not aware of a federal crime for being a member of a gang. Is there one? I know it's a sentencing enhancement. Is there a crime for being a member of a gang?
Well, in fact, that is some of the concerns that some advocates have, that if you are being considered a gang member because you live in a certain zip code and you're being associated, or is it really based on...
Well, I understand that
I
understand your concern is that it might catch too many people. My concern is the opposite, that it won't catch the right people. So it's not a crime to be a member of a gang. You have to commit another underlying offense, and then it's a sentence enhancement. So how are you going to determine who the gang members are?
Well, there are gang databases that exist. We assume, again...
So if you're in a gang database, will you be deported?
We don't have enough information from the administration yet, right? Remember, this was just announced.
Well, I've got the talking points that gang members are going to be deported.
But the talking points are not sufficient. They will be issuing guidelines with respect to how they will...
Who is they?
...program. The administration, the White House, and the Department of Homeland Security.